I'm attorney Susan Williams, and my job as a criminal defense attorney is to represent people who are in trouble with law enforcement. And throughout my career as a criminal defense attorney, I've had opportunities to represent juveniles in the state of South Carolina who have IEPs in place. And I wanted to let parents know or guardians know through this video the kind of things that you should be looking out for when your child has an IEP and is facing a criminal charge. So I'm going to go through the stages of a juvenile criminal case from start to finish, and I hope this helps a lot. So we're going to start with the interrogation process. First of all, we want to think about who is interrogating your child. Is it someone at school? Is it a school resource officer, a teacher? If it's not on school grounds, maybe it's at a baseball game, a football game. Is it a school resource officer? Whoever it is that's interrogating your child, do they know that the IEP is something that's applicable for this child? And if so, do they follow the IEP, the procedures that are in place for this plan? So that's going to be an important factor just from the very start of this case. And you want to make sure that the person who's dealing with your child knows about this plan, because it can affect how your child is comprehending what's going on. And if your child ends up getting charged with something, it is very important that you as a parent or guardian get that child's mental health records to the proper folks. I would recommend sending them to the child's lawyer so that the child's lawyer can look through, review those notes, and send them on to the proper folks, whether it be Department of Juvenile Justice or the prosecutor. But I would let your attorney go through those records first so that the attorney can determine what needs to be distributed. And you will definitely be speeding up the process by signing for these records, and because they're HIPAA rules that prevent even, well, they don't prevent them, but they put up a lot of red tape for even lawyers. So you would be doing everyone a favor to allow the attorney access to these mental health records. So going back to the interrogation, let's talk about the Miranda rule here. So if your child is making statements, we want to look at whether or not your child understood the waiving of their rights. Did your child understand that what they were being questioned about could later be used against them? If they made a confession, did they know that this would be used in court? Did they know that they had the right to an attorney? A lot of times people will say, well, I didn't know who my attorney was going to be. And the thing about Miranda is that you don't have to name an attorney. You just want to say, hey, I want to stop questioning, I need an attorney, and all of that stuff can be sorted out later on, but it should stop questioning. And if your child doesn't understand that, and they've given a confession or they've said things that are against their best interest, then that's something that can make or break the case, because through pretrial motions, an attorney advocating for your child may be able to get those statements suppressed through a suppression hearing. And so, the IEP certainly comes into play here, because we would be looking at whether the child understood their Miranda warnings. So going on now to the arrest. In South Carolina, we have a pickup order. You may not be signing a pickup order because your child may remain detained. But when I'm looking at defending folks who have IEP, I always look at, did the child have the requisite intent? An evaluation may be in order, competency evaluation may be something that an attorney can do before the detention hearing or the adjudication hearing goes forward. If the attorney has questions about the child's competency, whether they had a way of knowing right and wrong, and there are many other things to this, an attorney should, out of an abundance of caution, get this type of examination or evaluation done. So if there are co-defendants that were arrested for the same thing at the same time when your child was arrested, what is going on with their case? Are they being treated the exact same way that your child is with an IEP? And a lot of times I will separate my defendant, if I can, from the co-defendants so that I can see what is going on, what happened, how are they sentenced, and what happened with their case. And a detention hearing is when your child will be in court with their lawyer, a judge, Department of Juvenile Justice, the prosecutor, and you as parents or guardians will also be allowed to be present, and the judge may hear from you on what you think should be the best outcome on this case. And the judge will hear from the attorney, the judge may hear from my client, from DJJ, from the solicitor's office. So a lot of players come in here to this detention hearing. And one of the things I want to go over are zero tolerance policies. Those are things that are put in place. Certain courts have them. Certain solicitors' office have them, or prosecutors' offices. One of the counties where I prosecute, they have a zero tolerance policy for weapons on school grounds. And that means that they will not dismiss those cases. They will not recommend anything other than a 45-day detained evaluation. So it will be my job to convince the court otherwise and use your child's IEP as mitigating factors if those are applicable. I personally go over the colloquy with my client so that they understand what is going to be happening. If I get a feel or that this child doesn't understand what's going on, then I will go over the colloquy with them just before court so they don't forget. I don't go over the colloquy with all of my clients, but I do find that they're more comfortable with knowing, what is the judge going to ask me? How should I present myself in court? I always give a handout to my clients and the children so that the clients and their parents rather, so that they know what to expect. Nonverbal answers are not going to work because we have a court reporter. Stand up when addressing the court. Those things are very important in presenting in court. So then, just looking at the sentencing and placement, if your child is going to be detained, then we want to look at whether this place that they're going to is going to be able to meet the prerequisites of the IEP. Ideally, the placement would be consistent with the child's IEP and special needs. Of course, we don't always have that choice, but that's something to take into consideration. Spaces are limited in places, and unfortunately, we don't always have the ability to pick out where your child is going. That's something that should always be in the back of your mind. Finally, an IEP should be reviewed at least once a year. Doesn't matter where your child is, whether they're incarcerated, whether they're not incarcerated, where they are, it doesn't matter. Parents should be involved with these IEPs, and incarceration or placement at a boys or girls home or DJJ facility, Department of Juvenile Justice facility, should not have any, stop parents from doing this. I hope that this has been very informative for you, and I'm attorney Susan Williams. Thanks for listening.